All right. Welcome, everyone, to this September interim meeting of Licensing Occupations and Administrative Regulations. We appreciate everybody's attendance. We are going to get started by calling the roll.
Senator Adams. Senator Douglas.
Here.
Senator Higdon.
Here.
Senator Hornback. Senator Howe. Senator McDaniel. Senator Neal. Senator Nemus.
Present.
Senator Thayer. Senator Thomas. Representative Banta. Representative Bratcher.
Here.
Representative Birch. Representative Flannery.
Here.
Representative Gentry. Representative Herron. Representative Huff.
Present.
Representative Cook. Representative Massey. Representative McCoy. Representative Meredith. Representative Miller. Representative Moser. Representative Palumbo. Representative Pratt.
Here.
Representative Santoro. Representative Timoney. Representative Westrom. Co-Chair Schickel. Chairman Koenig.
All right. All right. We do not quite have enough to do our minutes. I know that Senator Thayer is somewhere on campus, so and we might have others come in. I know Representatives Banta and Massey are speaking to our state superintendents this morning and unable to make it, so that's a necessary, important item that they're engaging in. So we will continue with the agenda, and if and when we get to our number that we need for a quorum, I'll have us approve the minutes of the last meeting. So first up, the Emergency Medical Services Compact, Representative Hart. Please come on down. Floor will be yours. I know you've got one individual with you and a few others on Zoom. Are you all just the ones testifying and our Zoom folks are available for questions, or what's the plan?
The Zoom folks are going to be testifying as well. I'll just briefly, with me today is retired Brigadier General Steve Bullard with Kentucky. He's the director of the Kentucky Commission on Military Affairs, who I've been working with on this effort, and I'm going to allow him to introduce the people on Zoom that will deliver some testimony as well.
All right.
Well, thank you, Mr. Chair. It's wonderful to be here.
Is your microphone on?
Oh, I could.
There we go. Bring it a little closer and we'll be good.
All right. Well, thank you, everyone. And with us today, we also have Ray Mollers, Executive Director for the Interstate Commission for EMS Personal Practice, Doug Wolfberg, founding partner of Page Wolfberg and Worf, and he's the counsel to the EMS Compact, and he's the nation's foremost EMS legal practitioner. And we have Eric Sherman from the Department of Defense, Southeast Liaison for the Defense State Liaison Office, close partner of mine, of ours. So first, the Kentucky General Assembly has been a tremendous leader nationally in occupational licensing compacts. It's a priority of the Council of State Governments and the National Governors Association. And Department of Defense, in about the 2016 timeframe, came up with the concept of supporting occupational licensing compacts because they disproportionately affect military spouses from the transfers from state to state. So we want to do everything we can to ease that opportunity to work together as states and allow us to get licensing done as quickly as possible through the reciprocity process. Department of Defense since then has identified 8 priority compacts. Kentucky, through the leadership of the General Assembly, has joined 7 of those 8 compacts. The only one we have not yet joined is this one, the EMS Compact, which ironically is the very first DoD Compact. And the reason we did not join it was not supported by the then executive director of the KBEMS, Kentucky Board of Emergency Medical Services, a friend of mine, Chuck O'Neill. And Chuck was concerned about state sovereignty, protecting that and other issues. So he would not give this his support. And because of that, it never moved. So when I took this position over in late 2019, I reached out to Chuck and I said, what can we do to try to get your concerns addressed? And what we did last year was Chuck agreed to outline all of his concerns in writing so that we would have the opportunity to address those. We did that. That is in your handouts, the 9 questions that Chuck provided. Rick Masters from the Council of State Governments, with our assistance, addressed all of those questions very, very effectively. And then Representative Hart has done a phenomenal job bringing together the EMS community around the state. This is important because EMS jobs are difficult to hire for with certifications, and this would create a very positive effort that's been endorsed by the majority now of the EMS community. So Chuck agreed that those answers sufficed, and he moved his position early last year from opposed to neutral. He wouldn't go as far as support, but he went to neutral, and everybody else is strongly in support. And then Chuck wound up leaving that position, and they're in a position right now of hiring a new executive director. But we've done just tremendous work in moving this forward, getting the concerns addressed. And we really feel now is the time to move forward on this. So I know Eric has some comments he'd like to make real briefly. And if I could put it out to Ray, would you have anything to add?
Thank you, Steve. I would just like to add that.
Sir, please introduce yourself for the record.
Yes, sir. Ray Mollers, Executive Director for the Interstate Compact, the EMS Compact. I would just like to add that there are currently 22 states who have joined the compact, and 5 of which are neighbors to Kentucky, and that would be advantageous to Kentucky to join all that. That being said, I think this is an opportunity for the state, and as the administrative lead representing the 22 commissioners appointed to the commission to manage the EMS compact, I'm here to support the state of Kentucky in any way that I can, and most of all, here to answer any questions that you may have. Thank you.
And Ray recently had a nice conversation with Eddie Sloan, who's the interim executive director of the Kentucky Board of Emergency Medical Services, and I had asked him to run by anything he could possibly think of. And Eddie supports the concept. He says he's concerned about the law of unintended consequences, which obviously that's always a concern, but we really feel this is in a great position. And then lastly, Eric Sherman has a couple of minutes. He would like to address the committee as well from Department of Defense. So Eric, if you could introduce yourself.
Thank you. Good morning, Chairman Conant, Co-Chair Schickel, and committee members. My name is Eric Sherman. I am the Southeast Regional Liaison for the Defense State Liaison Office, or DSLO. We operate under the direction of Undersecretary of Defense for Personnel and Readiness and within the Office of the Deputy Assistant Secretary of Defense for Military Community and Family Policy. First, thank you for inviting the Department of Defense to discuss how the Emergency Medical Service Interstate Compact supports the military community. Excuse me. So if I may take just 2 minutes. This legislature has already reviewed and passed 7 professional licensure interstate compacts as previously stated. So members are already showing interest in compacts completing initial drafts. By now, this committee recognizes how interstate compacts standardize qualifications for interstate transfer, which alleviates confusion for military spouses transferring between member states. The committee is also familiar with the reciprocity concepts that not only support the military mobile lifestyle, but help the Commonwealth attract healthcare veterans transitioning out of service. Up to this last point, as a previous Navy Medical Service Corps officer, I'm most excited that the EMS Compact provides immediate recognition for our transitioning service members and spouses while expediting their applications. The committee has already heard from some of the others and is about to hear how the EMS Compact works. So at this point, I'd simply like to reiterate how much the DoD appreciates the invitation to testify so we can express the importance of these professional licensure compacts to our families. We want to thank Representative Hart for his support of the EMS Compact, thank the Kentucky Commission on Military Affairs for their partnership, and most of all, thank the committee for your time and attention to this matter. Although some states, such as Kentucky, extend an extra effort to help military spouses and employment opportunities, a military family's next move to another state can create a new set of problems since procedures are inconsistent from state to state. This situation is alleviated through interstate compacts. Kentucky is currently one of the most enthusiastic members of interstate compacts. So to this, on behalf of our military families, I'd like to thank you for your participation. And at this point, I'm just happy to answer any questions.
Eric, by the way, is a Navy vet. He, while he represents the Department of Defense, he represents the Southeast region and works out of Jacksonville, Florida. So he's getting hammered right now by the what is now the tropical storm, and we're happy he was able to still have power and join us today. That's the. I'm not going to go into the details of how the compact works unless anyone has any questions. But Representative Hart, let me turn it over to you and for any questions.
Yeah, this is what our third or fourth attempt of getting the legislation through. The legislation,
Yep.
It's changed to the effect that we were able to address every issue that K-Beams had and got them to come on board as neutral. At present, we are seeing no opposition from anybody that's raised a concern because we've been able to address all their concerns. So I would just like to strongly encourage everybody when we go back into session, we will be following the bill and ask for continued support on it and hopefully passage in committee hearing.
Very good. We have a question from Co-Chair Schickel.
Comment, if I may, Mr. Chairman.
Yes, sir.
Thank you. Interstate compacts are very common in this committee, and we're individual sovereign states for a reason. Mm-hmm. And in the Senate, we always approach these compacts with a lot of caution. And I know you appreciate that, Representative Hart, because I know you pretty well, and I thank you for appreciating that. We have every compact that we have approved in the Senate, we've usually had to make adjustments to during this session. So we'll be reviewing it carefully. Our General Counsel, Senator David Givens, has made this a special project of his reviewing these compacts. So we look forward to working with you on it. But I just want to emphasize that I do take state sovereignty very seriously.
And Senator Schickel, I will throw out as well, if you all could review this over the next several months, we're willing to make changes to the draft before we file it. So,
and I'll also add in that was, of course, Chuck O'Neill's major concern, and we have very strongly addressed the protections to the state to retain its sovereignty in these issues, and he agreed that he believed that it was sufficient what has been done.
Any further questions? Representative Meredith.
Thank you, Mr. Chairman. Representative Hart, you know, we sit on the EMS task force together. You know that one of my big concerns is always the workforce shortage that we see, and I understand trying to address this through this as you have military folks who are coming out of the service and possibly potentially coming into work for us. My big concern, and I think you've heard me raise this before in EMS discussions, is take the National Registry for EMTs, for example. Does this do anything to make a more strict or stringent pathway to licensure for our in-state folks like the National Registry did versus the state testing that we had back in the 90s?
No, it does nothing to affect the way we license EMS, EMTs, and paramedics in the state.
And I believe that's one of the questions addressed, in the responses to Chuck O'Neill.
Thank you.
Anything further on this topic? Seeing none, thank you very much.
Thank you, Mr. Chairman and members of the committee.
Next up will be electrical inspections. While Representative Pratt and his guests are coming up, we have reached a quorum with the arrival of Senator Thayer and Representative Gentry, so The chair will entertain a motion for the approval of the August 24th meeting minutes. We have a motion and a second. Any discussion on the motion? Seeing none, all in favor signify by saying aye. Aye. All opposed? Motion carries. Representative Pratt, the floor is yours. Please have your guest introduce himself.
Sir? Excuse me. My name's Alan Neal, and I'm electrical inspector in Scott County.
Thank you, Mr. Chairman. Actually, Mr. Neal reached out to me a while back. Right now, as the statute stands, is if you're electrical inspector, you can do no electrical work anywhere, anytime, in or your county or any other county. He would like to be able to, and that with, if you like me, have just recently done some electrical work. Luckily, after my 12th call, I found someone that actually do it. But he would like to be able to actually do electrical work outside of the county he works in. But right now, statute will not allow that, and I'll let Mr. Neal explain a little more about this.
As Representative Pratt mentioned, under the current KRS, inspectors are not allowed to perform any electrical work because for the inspector certification to be active, my masters, Kentucky masters, and Kentucky electrical contractors had to be put in an inactive status. They're not allowed to be active at the same time. And there's 3 ways that you can be an inspector as far as a state inspector to do state properties and such as myself, that you're hired by a local municipality, or you're a private contractor and you have permission from a county judge executive or a mayor to perform those inspections. And so, for instance, my jurisdiction is Scott County. Once I leave Scott County, I have no other authority in any other county. And given the demand for the workforce and the time that was put in to earn those licenses, and also I think it would be beneficial to be able to help nonprofits such as Habitat for Humanity or Men and Women of Action under the current laws that I can't perform that work. And it's just something that I've reached out to other people and then reached out to Mr. Pratt to see if this is something that we can make possible.
Again, he's not asking to do work in the county inspects. It's work in the outside the county where he's electrical inspector. We do not have a bill draft ready. We want to run a flagpole. And actually, the fact we got an agenda, I got some calls from some groups. After talking to them, they said they were fine with it. So this is the first step of many.
All right.
Be glad to answer any questions.
Any questions for Representative Pratt or his guest? Thank you very much for your testimony.
Yes, sir. Thank you all.
Next up, Mike Stone and his guests to discuss the issue of problem gaming and the solution for the topic. Mr. Stone has promised me that they will go for 10 minutes, 15 tops. It's a topic we are familiar with, and I've felt that it's important. We've heard from Mr. Stone before, and I believe that given the success we've had in gaming in Kentucky, we like to hear from the opponents that always causes problems, and it's important to bring solutions to those problems. That's what makes for good governing. So, Mr. Stone, floor is yours.
Thank you, Mr. Chairman, and Co-Chairman Schickel and members of the committee.
All right, is your microphone on?
I thought it was.
Well, then bring it a little closer, please.
Okay. How's that?
Much better, thank you.
Okay. Thank you, sir. And thank you to Co-Chair Schickel and members of the committee for this opportunity to speak. Good morning. I'm Mike Stone, and I serve as Executive Director of the Kentucky Council on Problem Gambling. With me today are 3 members of the Council Board of Directors, Dr. Scott Hunt, Dr. Curtis L. Barrett and John G. Arnett. Please note that their qualifications are in the full written statement that was submitted for the committee record. In the interest of time, I will summarize the highlights of the full statement in these oral remarks, and I hope the committee will be able to review the full statement. We will be pleased to answer any questions either this morning or later. Let's begin by making it clear the council is not anti-gambling. The council's mission is to increase awareness of problem gambling, promote prevention and research, and advocate for the availability of treatment. The council cites evidence that excessive gambling is a public health issue that can be best addressed through a state-operated program of evidence-based approaches to prevention, mitigation, and counseling. The council is not advocating for any funding for itself. It is advocating for publicly funded services for problem gamblers and his or her family and for society, all managed through the Department of Behavioral Health, Developmental, and Intellectual Disabilities. The council does not oppose nor advocate for gambling. Gambling exists. Statistics indicate tens of thousands of Kentuckians already are at risk or have a problem or an addictive gambling disorder, as defined by the American Psychiatric Association. That noted, the council does oppose illegal and unregulated gambling that preys on the vulnerable and makes no contribution to the public welfare. This opposition covers all forms of illegal, potentially illegal, unsupervised, and unregulated gambling. With expanded gambling available in Kentucky, more people will be closer to increased gambling opportunity. The need for a publicly funded problem and addicted gambling education, prevention, and treatment program is justified more than ever before. The availability of gambling opportunity in Kentucky can be seen in the maps presented in the slides accompanying this presentation. This is the horse tracks that are available in the state. The X marks the ones that have been granted but may not yet be in operation. This is historical racing venues in the state. This is charitable gaming, bingo halls, and other charitable activities associated with the associations and community groups. And that is the number of lottery retailers across the state. If people gamble, some will develop a gambling problem or addiction. A gambling problem is evident when someone continues to gamble in spite of recurring negative consequences resulting from the gambling activity. Some of the key statistics presented in Dr. Hunt's research analysis, which is attached to the full report, up to 160,000 Kentucky adults would have problem gambling traits. More than 64,000 Kentucky adults have gambling addiction. Almost 16,000 Kentucky college students have a gambling addiction. And more than 15,000 prison, probation, and parole adults in Kentucky have a gambling addiction. Point out that 19%, it's one of the major concerns with addicted gambling, 19% of those with problem gambling have considered suicide, and 4.7% of those with problem gambling have attempted suicide. Additional evidence that problem and addicted gambling is increasing in Kentucky is that participation in Gamblers Anonymous meetings is growing. In Lexington, the Gamblers Anonymous phone list has doubled in the last 2 years. Calls and texts to the 1-800-GAMBLER helpline also show a significant increase in the last 2 years. The call and text contacts increased 27% from 20 to 21, and those provided with a reportable service increased 80%. If you add in the numbers through the first 3 quarters of 2022, the number of callers and text contacts reported with a reportable service has doubled. As you can see from the maps of the locations of certified gambler counselors and Gamblers Anonymous meetings, they're minuscule compared to the availability of gambling opportunity. This is the GA meetings with accessible from Kentucky residents, and this is the location of the 7 certified gambler counselors that are in the state. The General Assembly did previously acknowledge the existence of problem and addicted gambling in the 2003 Legislative Research Commission report number 316, Compulsive Gambling in Kentucky. And let me take a personal side note here, that the resolution that caused that report to be drafted was introduced and led by Senator, then Representative C.B. Embry. And he has been a champion of this cause for the past 20 years. And I note that on the occasion of his announced retirement this week. The report supported the need for publicly funded program to address problem and addicted gambling. Next year will mark the 20th anniversary of that report, and there still is no publicly funded program to address problem and addicted gambling in the state. Society pays for the criminal justice and governmental social services in place to address the societal problems. The impact is far from just that individual. Society shares the cost. In the coming year, the state will receive about $400 million in receipts from legislatively sanctioned gambling. Less than 0.5% of the revenue from that legally sanctioned gambling would fund a credible awareness, prevention, and treatment program in this state. The council urges the General Assembly to designate a portion of the revenue received from legal gambling to fund a public program of problem and addicted gambling education, prevention, and counseling services. The opportunity and the means are before the General Assembly. I thank you for your time and consideration. Mr. Arnett and Dr. Barrett have a couple of brief comments, and then we are available to respond to any questions the committee may have. Thank you very much.
Very good. However whatever order you go in, please introduce yourself for the record and give us a minute or two of your experience. Thank you.
I'm John Arnett. I'm a formerly practicing attorney from Northern Kentucky, and I'm also a recovering gambling addict. I'm well aware of the need for publicly funded program for gambling awareness, addiction, and treatment. At the time that I was going through the active part of my addiction, there were no gambling counselors in Northern Kentucky. There are no treatment facilities in Northern Kentucky. I'm well aware of the need for publicly funded gambling programs for gambling addiction awareness and treatment. I've been in recovery now for 9 years, but it took being in prison for 3 years to break that cycle of addiction. I can't tell you what the addiction has cost me. It's cost me my career, my social status, and my finances are destroyed. That's all the comments I have.
Thank you, Mr. Arnett. I know you've been here in the past to speak to this issue, and we appreciate your coming.
Members of the committee, I'm Dr. Curtis Barrett. I appreciate very much the opportunity to share our science, our experience, and our hope with the members of the committee. When I entered the addiction treatment field back in the 1960s, it was true that if you wanted to place a bet in Kentucky, you had to travel to a racetrack or perhaps bet illegally. Today, if you want to do that, all you as an adult or a child need is to have one of these, and a myriad of gambling opportunities are open to you. I do hope that this addiction, which has humbled many of my patients in the past years, will receive the attention of the committee. It is greatly needed, and we have learned as professionals over the years that we can't do this by ourselves. It's too big for the professions. It requires a public awareness and public action and public funding. I hope that these comments today will underline that point. Thank you.
Thank you.
That,
That's the extent of the testimony.
that's it. We're happy to answer any questions.
I appreciate it. There are a few. Let me just make a couple comments first. House Bill 607 that was passed this past year. A couple items get a lot of the attention from it, but one that has not gotten the attention is that all the HHR facilities need to have a self-exclusion list for anyone who's having issues, and maintain that and share that with the other facilities so that we can address that issue in that way, which is obviously a free method of help, but it's one of many pieces of that puzzle. So I was glad that we were able to do that, and as I think everyone on this committee knows, I had a bill last year to take a windfall that we were receiving for a lawsuit settlement regarding illegal gaming, online gaming, for $225 million, and it was trimmed down by the House to $75 million in a floor amendment, but it got through and made its way over to the Senate, and that money is now going in the general fund, and I'm sure has been budgeted and on its way to being spent. So it's going to be we have to find a different method going forward. But I would challenge the members of this committee next year to find a way to make that happen. With that, Co-Chair Schickel.
Thank you, Mr. Chairman. I just, John Arnett is probably one of the oldest friends or longest friends I've had in Boone County, one of the first people I met when I moved to Boone County in 1977. And we've been through a lot together, and I take everything he tells me very seriously. He's talked to me a lot about this issue. And John, who would ever thought 40 years ago when we were running around together that this would be our topic? But I appreciate you being here. It's good to see you looking so well, and it means a lot for you to be here and to hear your testimony.
Thank you, John.
Representative Timoney.
Thank you, Chairman. Gentlemen, thank you for your presentation today. I've got very specific questions. A simple yes or no. Are you all aware of the gray machines that litter the Commonwealth?
Yes.
In your professional opinion, do you believe that those are gambling?
Yes.
Yes,
Thank
without
you.
a doubt.
Thank you, Chairman.
Absolutely. Representative Mosier.
Thank you, Mr. Chair. Thank you very much for your presentation. This is always enlightening. It's good to talk about. And I'm a huge proponent of treatment for any addiction. And I'm curious, when I read through the list of functions of these funds and the establishment of this board, in Section 1, 3E, you talk about, after all of the public awareness campaigns, talk about paying the cost and expenses associated with the treatment of addictions. I'm just curious about how these funds are accessed by the patient. To whom do they go, and how do you establish eligibility?
Ultimately, that will be decisions of regulations from the Department of Behavioral Health, Developmental, Intellectual Disabilities. Our, I guess, recommendation or discussion would be that those funds would flow through either a certified gambling counselor who would bill for services rendered as they do for treatment of substance uses, and that would primarily, and it's getting larger, go to insurance companies. Not all insurance companies cover addicted gambling treatment, so then there would have to be some kind of, through regulation, fallback that the funds in the program would support that counseling treatment. That would all come through the department. However, those regulations will be written.
Mm-hmm. Okay. Thank you. And if I may just quickly, one more. You touched on my second question about insurance coverage. And, a lot of times we work through these issues when we talk about specific diagnoses and whether or not there's a billing code. Dr. Barrett, I'm sure you're familiar with all of this. And, sometimes it's additional work to work with, the folks who come up with those ICD-10 billing codes. And that would be the AMA. And, is there a specific need for a billing code for gambling addiction? So, I mean, that's, another way to handle this larger problem of insurance coverage. I think this is good. I don't know that $150,000 is enough to cover any sort of real treatment, but I think it's a start for an awareness campaign. So thank you for bringing this.
Yeah, 0.5% of the money that the state will take in the coming year would be somewhere between 1.5 and $2 million that would then go to the work through the Department of Behavioral Health and be administered by whatever regulations that would be established. Yep.
Senator Thomas.
Thank you, Mr. Chair. And my question is both for Mr. Stone and Mr. Arnett. First, prefatory. Let me be very transparent so you know where I'm coming from. I've been supportive of expanded gaming in Kentucky since I arrived in the Senate. I'm supportive of sports gaming. Every time I've had a chance to vote on those, I voted for it. So I just want you to know where I'm coming from. Having said that, I do recognize that gambling is addictive, and I've had friends that have problems with it. So I want to begin with you first, Mr. Stone. And my first question is, how does this work? Are we talking about what we see with regard to alcohol addiction or drug addiction, where we wean someone who has a gambling problem off of gambling? Are families involved, like we do in alcohol and drugs? Are there peer counseling sessions or peer sessions where those with gambling addictions get together and talk about their problems and work out again their getting off of gambling and not doing it again? How do you see this working in terms of the nuts and bolts?
Simply yes to everything you said. All of those activities are in practice and operation in many of the 40 other states that have publicly funded programs. The specifics of how that treatment would affect, I've been told that I'm not a counselor. I do the administrative work for the council, but been doing it for 24 years, so I've attended some meetings and listened to folks talk, and the road to recovery is first self-awareness, and then in large measure it is professional counseling services to identify what the real root cause is of the addiction, and then continuing care through Gamblers Anonymous. And I'd certainly defer to Mr. Arnett and to Dr. Barrett, who's a certified gambler counselor, on the specifics of how all of that takes place.
Okay. Mr. Arnett, do you want to respond to my question?
Could you rephrase it, please?
How do you see this working? When the state appropriates money for people who have an addictive problem when it comes to gambling, what are the processes by which you treat that addiction and get that person off that addiction?
For a start, we need more adequate certified gambling therapists. At the time of my addiction, there are none in northern Kentucky. And unfortunately, by the time I found a gambling therapist in Louisville, I was too caught up in the throes of my addiction for it to really benefit me. Secondly, Representative Moser mentioned about insurance. Unless it's changed dramatically, there are no private insurance companies that cover gambling addiction. And if there are very few. So I didn't have the help that way. The biggest problem that I had when I was in the throes of my addiction was being aware of how I was sliding into it completely controlling my life. So hopefully the legislation would fund first the employment of gambling therapists. Secondly, it would fund treatment programs. When I saw a need for an inpatient treatment program, I had to go outside of this state to even look at such a program. The cost of an inpatient treatment program is far in excess of what I believe an alcohol in treatment program is. I saw a range of anywhere between $12,000 to $50,000 for a 30-day program. So that would be the second way it would benefit someone like me.
Okay.
Hope that answers your question.
It does, and being from Lexington, I have to say I'm dismayed to see in your PowerPoint that Lexington does not have a certified gambling counselor. I'm just shocked to see that takes place. I see the doctor over there shaking his head, nodding that is indeed the case. My second question is this, and I'm back to you, Mr. Stone. What do we do in areas? I know we do a lot with drug addiction. The state, in fact, this past budget cycle, we increased our appropriations significantly to deal with drug addiction efforts across the state. What do we do with regard to alcohol addiction? Because we've had alcohol in Kentucky as long as we've had gambling. So do we have a similar type of program for people who have alcohol addictive problems?
I'm all for that, but I don't know that any of these folks have expertise in that.
Okay.
There.
I wish our current president, Dr. Ronsland Clark from Owensboro, could answer that question very specific, and I can ask her to send you that response. She is a currently practicing substance use disorder counselor,
right.
and she knows the absolute details of that.
Because it just makes sense to me that if we're going, I think we should do this for gambling. I'm on board with this. But I think we should do something similar. If we don't, we should do something similar regard to alcohol. People have alcohol problems as well.
Thank you, Senator. I think I'm not an expert in this field, but from the research I've done, I think it's safe to say that there's a lot of crossover between issues with people. So there's you get them in one place, you might get them in give them a holistic bit of help. Representative Gentry, you're up next, and then we got two following you, and then we'll need to move on.
Thank you, Mr. Chair. I'll try to be brief. My question was more related to, or more directed toward John. But before I ask the question, let me just make a quick comment. Mike, I've been a supporter of this, and appreciate you guys being here. As you guys know, as many of my colleagues on this committee know, I am a big advocate for gaming and expanded gaming, okay, if it's done right. And I've always said one of the glaring omissions in that activity in this state is this issue right here. Just about every state across the country that has legalized gaming has some sort of tax revenue provision that contributes to dealing with this addiction. It is a real thing. You can argue whether it's 2% of the players that play or 6% or whatever it is. I've seen a variety of research on that matter, but it exists. It's a community cost, and I'm a huge supporter of putting public funds aside from tax revenues that are gathered in these activities to put a robust program together to treat this problem, because we know it's treatable, because John is a living example here in front of us that if people get help quick enough, it can be treated. And my question to you, John, is, in this particular piece of legislation we have in front of us, there's a $150,000 number. I think we know that's peanuts. And you probably don't have the answer to this. Senator Thomas has hit on this a little bit, asking you how this would work, and my question was going to be more on the lines of what is the most effective measures, where could we use funds more effectively, which you have answered that from a counselor standpoint. Any ideas, and I guess this could be directed to any of you guys, to have a very effective program in place, what kind of budget do you think you would be looking at for the state of Kentucky in dealing with existing gambling, legalized gambling that we have right now that's already going on? And give us an idea, if you have an idea, of how underfunded we might be, even at $150,000 a year.
The National Association of Administrators of Disordered Gambling Services, that's a mouthful. That's administrators among the 40 states that have publicly funded programs. They did a survey and indicated that 23 cents per person was the average funding that was public funding that was dedicated across the states in the survey. And you extrapolate that out, it's somewhere between 1 and 1.5 million, depending on how many population, which segment of the population you want to talk about. Full population, the adult population, whichever you want to carve out. So that's the best reference figure that I can give you, sir.
I appreciate that, and I know once you get rolling and really start treating patients and having successes, you're going to have a lot better idea of exactly what it costs to run the most efficient program for us. But I think the biggest thing right now is for all my colleagues to understand is the real need to put this program into place and to provide some public assistance so that it can be an effective and efficient program. Thank you very much, Mr. Chair.
Thank you. Representative Birch.
I'd like to know, when you were in treatment, how did they treat you to back off from being a problem gambler? What incentives did they give you to stop gambling?
Okay, I'm assuming that's directed to me.
I'm directed to the person that had the treatment.
Yes.
Okay, that's me, John Arnett. Well, let me say first, the treatment that I received was much too late. I went to a therapist after I'd been into active gambling for probably 7 or 8 years. I'd never gambled at any casino location in my life until 1999. And it didn't take long for the addiction to take hold of me, because the thing that happened to me first is the thing that is the worst thing that can happen to a gambling addict. And that is, I won big. I won a huge amount of money. I'm talking big numbers. If you want to know the number, I'll mention it to you. I never had a profit for the next 15 years. So by the time that I was aware of my problem, my family was well aware of the problem. They were asking me to seek help. But you've got to understand, an addiction this powerful just takes over everything about your life. By the time I sought treatment with a therapist in Louisville, it was a little too late. You asked me, what do they do to help you get away from the addiction? I'll just give you a line that the doctor gave me at the time, and that is, I'll give you the tools to beat this addiction, but it's up to you to pick those tools up. I was too destroyed to be able to use those tools. And by the time I was in treatment, I'd already was involved in some criminal activity that resulted in me serving time in prison. More importantly, it would have been really beneficial if we'd have had some therapists in my area so I wouldn't have to travel such a distance to seek help. Secondly, it would have been immensely helpful to me if I could have gotten in an inpatient treatment program early during the cycle of addiction. And something I want to make really clear to all members of this committee. Gamblers Anonymous is not a treatment program. It's a volunteer program for people with a gambling addiction and members of their family if they want to attend. And basically what Gamblers Anonymous doesn't really make you aware of what the gambling addiction is. It just gives you an opportunity to voice your life and your activities and what has happened to you in a group of other similarly minded individuals. It's not intended for treatment. It's like a group session. If you were an alcoholic or drug addict, whatever, it's a group session. I can't tell you how many members of that organization that we've had people come to the group session, tell us their story, and you can see what direction they're going, and you never see them again. It's rare that you have someone like me that's a recovering addict and it stays in recovery. In the 9 years I've been in recovery, I've never fallen back one time. I've never gambled one time. There are people in the program that I attend that have gone back to gamble because they thought, well, I'm okay now. I can handle this now. So I can't persuade you enough to be in favor of legislation like what we're proposing to help fund, first of all, awareness. That 800 number that you see advertised, forget that 800 number. All you have on the other end of that line is someone answering some questions you may have. It's not really directed to a program or a therapist. So I just can't emphasize enough the need for this type of program and this type of funding.
Well, one thing I would suggest that you increase the money you're asking for to start with, and I think the industry that helps create this problem should also be contributing money to that treatment also, because they're, by offering this service, they're offering the fact that people can become addicted, just like alcoholism is, of course, is an addiction too. And I never suffered from alcohol problem, but my dad did, and AA helped him as long as he stayed in it. But once an alcoholic, you're always an alcoholic, and I'd say once you're a problem gambler, you are, and you on guard at all times, I would think.
Absolutely.
Not to fall back into that problem.
Thank you.
Thank you, Mr. Chairman.
All right, we're going to have a short question from Senator Douglas, a short question from Representative Cook, and a short statement from Senator Thayer, and then we'll be done with this topic and move on to our final one. Go ahead, Senator Douglas.
Thank you, Mr. Chairman. And gentlemen, thank you so very much for your presentation this morning. Instead of a question, I'll make this a very short, just sort of eye-opener. There's no doubt that we don't have enough certified gambling therapists. None of us could even come close to how many are out there at this particular time. One of my concerns is always with starting new funding streams. It seems that we have universities that we already pay for to a great extent. And and much of what we need to do is produce counselors. Those are things that we can do through other areas rather than creating new funding streams, especially when we're going to try to produce therapists that we can produce through our universities. There's no doubt that there are a lot of degrees that are being offered now that really have no end point in terms of end jobs. I'm more than happy to listen to you all move in this particular direction, but I do think we need to start utilizing some of the facilities that we already have instead of creating new funding streams. I think our taxpayers in the Commonwealth are probably getting a little bit tired of having to pay for a lot of things that perhaps they don't really participate in. And so I just want to throw this out for this committee and for the General Assembly in general. Instead of creating new funding streams, simply look at some of our pre-existing avenues. Thank you very much, Mr. Chairman.
Absolutely. Representative Cook.
Thank you, Mr. Chairman. I supported your problem gambling bill last session. I thought it was a pretty good idea, especially everything that we've done. My question for you, gentlemen, is do any of the charitable gaming, the pari-mutuel wagering, the lottery, all the VFWs, racetracks, is there any gambling organization out there that contributes to the problem gaming?
Number one, in terms of our council funding, most of them do contribute to what we do. We have a budget of about $80,000 a year, and we are the ones that provide the 1-800-GAMBLER helpline service in cooperation with River Valley Behavioral Health, and the awareness information. The Kentucky Lottery pays for part of the tax check services additional on that contract, and billboards that you might see on problem gambling. Otherwise, the horse racing industry does use signage at the venues and in their program books about the publicizing the 1-800 number. But most of the awareness money for this issue is what they contribute to our council. As I say, it's of our $80,000, the industry is probably $50,000 of that $80,000. So that's the contribution that they are making. And if I can add just slightly a general statement that the focus has seemed to be on the treatment issue, and that is definitely important, but the prevention and awareness aspect of this issue is maybe even more important to, as our society moves towards a legitimization and acceptance of gambling as part of our culture. We need to have programs that educate and make people aware of what the potential is. And that is also what a large part of the money that we're talking about would go toward.
And Senator Thayer.
Thank you, Mr. Chairman. I appreciate Senator Douglas's comment, and I'm going to sort of follow up in the spirit of that. I'm not saying I'm for this. I'm not saying I'm against this, and I appreciate your efforts, but human activity is addictive, and we have all sorts of activities that people get addicted to that are legal. We spend a lot of money on counseling and prevention for things that are illegal, like drugs, which continue to be a pervasively negative influence on our society. And my rhetorical question today is it really the job of the taxpayers to fund recovery programs for addictions to things that are legal? So I'm just going to leave it at that.
I do appreciate the comment. We do that the evidence that has been collected in academia and other states is that there is a significant social cost involved from gambling, and with the state receiving as much money as it is coming from the gambling that it sanctions, that it seems reasonable to us that a portion of that go towards prevention, awareness, education, and treatment.
Thank you all very much. We appreciate it. And we have one last topic. Joshua Gaines, who is testifying remotely. We might need some computer expertise to get out of that and get Joshua up. I had the honor of being one of 3 members of Kentucky to be part of a national consortium to discuss best practices in licensing. I believe it was funded by National Governors Association, CSG, and NCSL. We had it was slowed down a little bit by COVID, but we had a final conference to go over all our topics, and Joshua gave a presentation which I thought was very good, and I thought it would be important for the committee to hear what Joshua and this consortium came up with on this topic. So Joshua, I appreciate you sitting through an hour's worth of other topics so that we can hear what you have to say, and please introduce yourself for the record, and the floor is yours.
Absolutely, and thank you for the invitation. It's a pleasure to be here. I'm Josh Gaines. I'm a project manager for the Corrections and Reentry Division at the Council of State Governments Justice Center. I wanted to talk today about expanding access to licensure for Kentucky workers with criminal histories and really frame it within the context of national best practices, what other states are doing, where other states have found success in terms of policies.
And let me just say, I think there's information in everyone's folder on this. Please continue.
Correct, yes, and I'll be referring to some of that as we go through this. Real quick, if you're not familiar with the Council of State Governments Justice Center, as the chair mentioned, we were involved in the National Occupational Licensing Consortium, along with NGA and NCSL. We're a national nonprofit, nonpartisan organization that combines the power of a membership association serving state officials in all in all three branches of government with policy and research expertise to develop strategies that increase public safety and strengthen communities. A short way of saying that is we are sort of the criminal justice focused arm of CSG, which obviously is a much larger organization with a much broader focus. One of the things that we've been doing over the past 2 years is engaging in what we call our Fair Chance licensing project. We've worked on this in a broad array of states, and our role on this project, sort of like my role here today, is to identify best practices and provide national context for the states. We're interested in helping states recover from the economy, enhance good paying job access, improve re-entry and public safety, and provide businesses with a qualified candidate pool. And just as a little plug, if you have any additional questions, you can always feel free to reach out to me, and I'll have some email information at the end. But we also have a website for our project that includes an overview of issues, explanation of best practices, and stories from legislators and impacted people, which I encourage you to visit if you're interested. So since we're talking about people with criminal histories, I want to provide just some broad context about that. A 2022 analysis done by the Prison Policy Initiative based on a cohort of people released from federal prison in 2010 found the following. 33% of those released never found a job within 4 years after release. 60% or more were jobless at any time during those 4 years. And for those looking for work, the unemployment rate hovered around 36% during all 4 of those years. For the people that were able to find work, most of the jobs were unstable and the earnings were well below the median income. Now, I mentioned that's data based on a 2010 cohort, which is the most recent data that the Federal Bureau of Prisons had available. But this is borne out in more recent research as well. So a 2022 RAND Corporation study using data from 1997 to 2017 estimates that 46% of unemployed men have a conviction record for a non-traffic offense by the age of 35. And it's probably no surprise that these discrepancies in employment rates among the general population and people who have been involved in the criminal justice system, much like many others, differs widely based on race. So you can see on this chart on the left-hand side, these are the discrepancies in unemployment among racial groups and genders for the US population age 35 and 34. If you look on the right side, that's the same group for people who have been formerly incarcerated, those unemployment rates. And you can see between white men, black men and white women, the difference in those rates expands dramatically. And of course, employment is a public safety issue. People who can work are less likely to reoffend. They form more positive social relationships. They're able to provide for themselves and stay away from illegal activity as a means of potentially providing for themselves. And they're able to engage in pro-social activities. There are also a lot of economic benefits to putting people who have been involved in the criminal justice system back to work. One study found that $87 billion are lost annually due to barriers to work faced by people with felonies. A study in Philadelphia, it's a bit old, in 2011, found that putting 100 formerly incarcerated people back to work resulted in a 1.9 million lifetime increase in tax contributions to the state including a 770,000 lifetime increase in sales tax revenue. So the economy has a lot to gain from this as well. So why is licensed work important for this population? Here's some quick numbers. 20% of Kentuckians are required to hold a license to perform their occupation or job, according to a 2018 study. The hourly wage difference between workers with licensure and workers without licensure is $6.20. That again is according, and that's a national figure I should add, but that's according to a 2018 study as well. So licensed jobs are good jobs. They are generally more stable. They pay better. They have opportunities for upward mobility that are often lacking in unlicensed jobs. At the same time, there are 292 provisions of Kentucky statutes and regulations that create barriers to licensure for people with criminal histories. There are a few features of those barriers to licensure. The two most important when we analyze them are whether they are time limited, that is, whether a barrier to licensure expires a certain amount of time after you've been convicted or completed your sentence, and whether it's mandatory or discretionary, which is to say whether the barrier has to be imposed in every instance where a person has a disqualifying conviction, or whether the decision maker, the licensing board, can choose whether to impose it or not. In Kentucky, 83% of these 292 barriers are indefinite in nature. They persist for the duration of a person's life, generally, unless they receive relief in the form of expungement, sealing, a pardon, or something similar. To give you an idea of sort of what these look like, this is the law governing licensure of cosmetologists in Kentucky. You can see here, this is a discretionary barrier. The board may refuse to issue or renew a license for conviction of a felony in accordance with Chapter 335B, which we'll look at in a second. So what this is essentially saying is if you have a felony, we may deny your licensure for cosmetology, period. Now, you don't have to, if you are on the cosmetology board, deny somebody with a felony. So it seems in that sense that it's far preferable to these kind of mandatory barriers and provides kind of a way out of some of the more draconian, unfair, harsh penalties to licensure faced by people with criminal histories. But that's not necessarily the case in practice. So I'd like you to consider for a moment what it looks like for a person with a criminal history, with a felony in Kentucky, thinking about going to get their cosmetology license. The calculation they have to walk through is, should I spend 12 to 16 months in a training program for cosmetology that will get me my general licensure requirements? And that figure is from data relevant specifically to programs within the state of Kentucky. And should I spend $12,568, which is the average program cost in Kentucky for tuition expenses, if licensure is going to be uncertain because of my conviction? Because the fact is, you cannot get a determination in Kentucky about whether your criminal history is disqualifying until you meet those general requirements and are able to apply for a full license. As a result, many people say, you know, I will do something else. And there is a lot of self-selection out of any licensed occupations, even those that people would ultimately be qualified through if they were willing to take the risk in investing time and money up front. So this is just one of the issues that states have tackled recently. Over half the states have enacted broadly applicable fair chance licensing laws in one form or another. They're based on three major principles. One is that licensing bodies ought to have the authority to deny applicants with past convictions, so long as they're related to the task and duties of the licensed activity and pose a appreciable risk to public safety. Workers should be given individualized consideration. They should not be denied automatically because of any conviction. Their particular criminal conduct should be looked at as unique conduct, and their circumstances before and since should be considered as unique. And finally, that any disqualifications should be transparent and consistently applied. And the state of Kentucky has actually gone really far to implement a lot of these things. So I mentioned Chapter 335B earlier. That was put into law largely in 2017, and it does a lot of, or incorporates a lot of the best practices that we talk about and that we see in other states. So it does require a direct relationship between an offense and a licensed activity. It does require individualized consideration. And it provides some additional procedural protections and puts a limit on disqualifications based on vague terms like good moral character. So the question is, where can Kentucky go? What's still out there that could be really impactful, that could increase access while continuing to maintain public safety? And based on our analysis, when we look at Kentucky, the big one really seems to be this pre-application determination process. And what that is, and there's a separate sheet with your materials that goes over this in some depth, is really taking that risk reward calculus that I mentioned earlier and flipping it around, right? So instead of having to invest time and money upfront for a license that you don't know you can get due to your criminal history, it allows you to ask a licensing board to make that determination before you make that investment, right? So in many states, you can now at any time before you enroll in an educational program, submit a formal request to a licensing board, say, this is my criminal history, submit any other relevant information that you may have, and say, you know, all things being as they are now, if I applied for licensure, would I be disqualified? If that's a yes, you make that investment and you get your license. If it's a no, generally you can go back to the board at a later date, perhaps after you've received treatment or rehabilitation, anything like that. Or you can still, decide to take that risk and apply for licensure. So it's not locking people out of the system, but for people who would apply, it creates a gateway, for people who would be approved, it creates a gateway for them to get into the system and ultimately into these jobs. And this is something that's been really successful in a lot of states. So 20 have now fully implemented these sorts of procedures and authorizations in law. And I should note that although this is something that could be done at the regulatory level, when we talk to states, it's very important, they find, especially to regulators, to have statutory authority to make these kinds of determinations, because they do not want to be caught in a position where they make an informal determination for somebody and then have to be held to that later on without any sort of statutory authority to back that up. 2 states here have partially implemented it, Nevada and Kansas. The reason we say they partially implemented the policy is because those decisions are not binding upon the licensing boards. And since those decisions are not binding, they don't necessarily mitigate much of that risk that these policies are meant to alleviate. This chart's a little outdated since this last session. Connecticut, Delaware, Los Angeles, Oklahoma, and Wyoming have all joined these other states in implementing pre-qualification procedures. Real quickly, I'll just talk about a few other of these major best practices that are missing. One is broadly limiting consideration of older convictions. A lot of states have done what or made decisions, policy decisions consistent with data that shows that the risk of reoffense for a person drops dramatically after just a number of years. Often in 4 years without justice involvement, the reoffense rate of a person who has been convicted of a crime goes down to that of someone who has never been convicted of a crime. So a lot of states have put hard time limits on the age of convictions that licensing boards can consider. And you can see in this map, 11 have done that fully, 8 have done that partially, and those 8 partial states generally create time limits only for certain types of convictions, lower level offenses, or create a presumption of fitness after a certain amount of time. Similarly, a lot of states have said, there are certain low-level offenses that should never or will never create a public safety concern in the context of licensed work, so they broadly prohibit licensing boards from considering them. These are often things like non-violent misdemeanors, for example, or all misdemeanors in some states. And you can see here that 9 states have fully implemented that, and 3 states have partially implemented those policies. Few other things lacking in Kentucky. briefly, and then I'd love to answer any questions you may have. One is that Kentucky law does not explicitly prohibit the consideration of certain dispositions that, as a matter of public policy, should not be related to legitimate public safety concerns. So those include arrests that were not followed by conviction. 17 states now explicitly prohibit that. Juvenile adjudications, 9 states now prohibit that. And then consideration of expunged, sealed, and pardoned convictions. And 27 states now do that explicitly. I think as a matter of practice, when we talk to licensing boards, and I have yet to have any in-depth conversations with boards in Kentucky, we often see that these things are often done as a matter of practice. It's just not in the statute, and it's not clear often to people who are applying for licensure or interested in pursuing licensure. And you'll see kind of a running theme through all of this, which is the more information that we can provide to people with criminal histories who are interested in licensed work, the more the confidence we can give them to pursue that work and to pursue those opportunities and to ultimately get those good paying jobs that keep everyone safer, that allow employers a bigger pool, that contribute to the economy over time. And so this last one is really increasing transparency, second to last one, in the application process. There are a number of states that by statute require licensing bodies to just publish accessible information for applicants online about how criminal history is considered. Finally, one thing I just have to add is that I mentioned Kentucky does require individualized consideration of applicants. The nature of the crime has to be considered, time since conviction, and its relationship to the duties of the job. One thing that is missing, conspicuously absent compared to what we see in other states, is a requirement that evidence of rehabilitation be considered. I think as a matter of course, that's likely happening at the board level. But putting it in statute front and center really allows people who have criminal histories an opportunity to gather that information, to focus on that information where it is relevant. And I don't want to take up too much of your time. If you're interested in some of those broader policies, I encourage you to look at the Fair Chance Licensing Project at that handout, but I'd love to answer any questions you all have. And thank you again.
Thank you, Josh. I appreciate you bringing that presentation to us. First of all, if you could send us that PowerPoint so that we can have it for our records and put it on our website as a resource for everybody for our meetings. And, two of the things that came to my mind when I sat through that presentation was that it can assist us with two issues that we have. One is our workforce issues, small piece of the puzzle to help fix that, as well as, I've been here 16 years. We've passed several bills that we're going to fix our growing incarceration problem. And I'm not saying they weren't effective, and they certainly had plenty of data to say that they were going to work, but we still have overflowing prisons and plenty of people that if we had space would not be out on parole but would be in prison. So if we can get people back to work and keep them from returning back into that cycle, that would be, I think, very beneficial. And one thing I want to point out, or I guess ask Josh, it was pointed out to me by Senator Thomas that if we're going to, talk about a bill to get basically pre-approval, it's important to note that, if you go through the process and you go through the training, that you not have any other issues in between those two time points where you get the approval and then get through the training and get your final licensure, correct?
That's right. And that's a common feature of all of these laws. And I think that additional little memo about pre-qualification will speak to that. Almost universally, the states say, this decision is binding insofar as either your criminal history does not change between the time you got the decision and when you apply for licensure, or the criminal history that we reviewed or that you submitted was incomplete. and which would be found out once a full background check and investigation is done at the time of licensure or the time of application.
Thank you. Co-Chair Schickel.
Thank you, Mr. Chairman. I have a little different point of view than my co-chair, and I want to express it because I too sat on the Council of State Government Reentry Commission and was very disappointed with their work. First of all, as the chairman said, we have had lots of bills to reduce our prison population and make our workforce better, and for the most part, they have not worked, and this will not work either. The crux of the matter of this kind of legislation is this: who has the authority to regulate professions? The very definition of a profession is they set their own standards. And what we are saying is, no profession, we know better. We will set standards for you. And this argument I reject. I rejected it on the commission, and I reject it now. The other thing I reject is the standard is public safety. It may be public safety, but it's not always public safety. This idea that a felony conviction means nothing unless you're a risk to public safety, that's not for us to decide. That's for the profession to decide. Thank you, Mr. Chairman.
Absolutely. Representative Moser.
Thank you, Mr. Chairman, and thank you very much for your presentation. I thought that this was very well thought out. I actually passed a bill in 2021 called Certification of Employability for incarcerated individuals that really sets folks on the right path. It's just moving in the right, giving these individuals the ability to move forward and get the training that they need. I don't know that I really heard you say that this is necessarily taking the place of a licensure board in making the decision. It seems to me that you are working toward a pre-application determination, which would help an individual understand what the likelihood of their being licensed is, and kind of, just moving them in the right direction. Is that what I heard you say? I'm after the last comments, I'm a little confused.
I think that's right, if I understand you correctly, and I should clarify this pre-application process is procedural in nature. It takes a determination that happens at a later point in time and moves it up to an earlier point in time. The standards that are used to determine, whether a board says yes or no would not be any different. They would apply and they would be, consistent with current Kentucky law. The only difference is that a person would get that determination before having to make the investment in education and training.
Okay.
So, and I hope I understood your question correctly.
Absolutely. That's exactly what I was asking, because, I think that we are making strides in having passed Senate Bill 120 and House Bill 497, the certification of employability, and using some of these qualifiers to move individuals toward licensure, which would be more tangible and binding for those individuals who are seeking employment and seeking to stay out of the criminal justice system. And I think that that's really, I know that that's the goal here. Are there other pieces that we can add? Absolutely. And I think that you've highlighted some really good points in assisting individuals to get out of the criminal justice system and into employment, which we know reduces relapse and recidivism and all of the problems that we're seeing. So I am in favor of this, and I appreciate that I had some very great conversations with Senator Schickel during the process of passing certification of employability, and I believe that you even stood up on the House floor and defended it. So I really appreciate that. You're welcome. And I think that there's room to work on some of these issues, and I just thank you for your presentation.
Thank you.
All right. Seeing no other questions, thank you, Josh, for the presentation. Thank you, everyone, for your attention. We've come to the end of the agenda. The next meeting is October 27th. I feel pretty certain about that. So mark that down, and if changes, we'll let you know. And with that, we stand adjourned. Thank you.